He was, maybe charged with making threats to use defensive violence, but no violence was ever actually used. And I want to point out, there are no allegations that any of the Brown supporters used violence in connection with this case, except one allegation in Texas that resulted in dropped charges. I want to remind folks, whatever their faults, the Browns apparently didn't use violence, while the federal government used violence on at least 6 separate occasions in order to bring this situation to a close. Now, it was a lot less violence than they could have used. It was a lot less than Waco, a lot less than Ruby Ridge, but they still used violence 6 times, and the Brown supporters used it between 0 and 1 times, depending on who you talk to. Of course, important also to remind everyone, the Browns did not attempt to force you and me to pay for their activities. The federal paramilitaries did force us to pay for their activities. Through the gas tax, the corporate tax, the income tax, the telephone surcharge, although I think that may have gone away, and any number of other hidden taxes that the federal government imposes upon the American people. The judge said Riley was not eligible for probation. His attorney, who he rejected, his rejected attorney's name was, I think, Mr. Weberg, but I never got his first name. After Danny's 15-minute long, rant or theorizing, whatever you want to call it, the judge began speaking, and he said, quote, he talked about the quote, need to protect the public from further crimes, unquote. The judge, I believe his name is Singal, I'm not sure if I'm saying that right, George Singal. He said, quote, he helped, judge said, quote, he helped string explosives on trees, unquote. The judge sounded like he was the accuser, as though he had actually been there and seen these things. The judge didn't say, there's overwhelming evidence that you strung explosives. He didn't say, the jury found you guilty of stringing explosives. He just said you did it, as though he was there, and I found that to be troubling. He said that, and he made various other accusations against Danny. You did this, you did that, you did this, you did that, again, as though he was there and saw it. I'm guilty of the same thing sometimes, and that came up later in a conversation where I said something happened and I hadn't actually seen it myself. We're all guilty of that, but again, the government is the only institution they're the ones that are actually forcing you and me to pay them to say these things. I don't force anyone to pay me to say anything. And when it comes to saying that certain things happen that I didn't see myself, I am trying to change, trying to stop doing that and only report that something happened if I saw it. Otherwise, I should be attributing it. Hard habit to break. The judge said, quote, in my view, this defendant is a dangerous man. The judge also said, quote, this court will not permit such conduct to occur in society. Which of course is not accurate. The government cannot stop bad conduct or good conduct from happening in society. They don't have that much control. They can occasionally punish something that happens out there. Eventually, the judge sentenced him to a total of 432 months in jail. That was maybe 20 or so months less than what the prosecution had asked for. He's supposed to be, if he's even still alive when he's released, because that's 36 years, he would get 5 years of what they call supervised release. They spent a lot of time talking about the things he would not be allowed to do after he gets out of jail in the year, 2040 or whatever. This is nice. They said after he gets out, he's to be subjected to drug testing, not to exceed 72 drug tests per year. At that point, the prosecutor kind of gave backhanded confirmation of what I've just been telling you. I tell you about how what the judge had to say was so complicated. Well, the prosecutor didn't even understand the sentence and had questions for the judge about what the sentence actually meant. Another thing that the judge said that was complicated, hard to understand, he said Danny was he had a level 2 criminal history. I have no idea what that means. and I shouldn't have to know something like that in order to understand what a judge is saying. Is level 2 a lot of criminal history? Is it no criminal history? Limited criminal history? It could mean anything. The judge's demeanor was largely professional, but he did, do a lot of this, while Riley was talking, which again is relatively understandable because Riley was saying relatively strange things. But he was consistent, and again, he doesn't force you and me to pay for what he says. The government does that. Riley is not accused of using any weapon to hurt anyone in connection with this case, and yet the government is hurting someone probably at this very second with a weapon. Probably 10, 20, 50 people right now. It was interesting to note the contrast between the way the judge's demeanor was towards Riley and compared to his demeanor towards the prosecutor, Arnold Huftalen. I don't know if I'm saying that right, Huftalen. It's one of those two pronunciations, I think. The judge was very friendly, sort of buddy-buddy in his talk whenever he would turn and say something or ask something of the prosecutor. When he would turn around and talk to Riley, it was just, he was, again, professional but very terse.